Hey, oh, folks. Yes, time to get to know Kelsey Fitzsimmons' reply to the Commonwealth's reply to her application to not be in jail that has been submitted to the Massachusetts Supreme Judicial Court. And I skimmed through it. Oh, they're not pulling any punches. Let's just say that. This is hardcore legal document. Welcome to the show. All right, let's read this. And if I have comments, I will have comments. Or we will simply just read it and listen. Commonwealth of Massachusetts Supreme Judicial Court, docket yada yada yada, Kelsey Fitzsimmons, appellant defendant, versus the Commonwealth, appellee. Reply brief for appellant Kelsey Fitzsimmons, date December 3rd, 2025. Respectfully submitted for the defendant, Kelsey Fitzsimmons, by defense counsel Timothy Bradel and Martha Coakley. Table of contents. We don't really need that. Table of authorities. Table of authorities is, hey, this is our quotes. We are quoting the case law, the things, and as you can see, only two. Stack versus Boyle, 1951. Commonwealth versus Berthold, 2004. Introduction. Now comes appellant Kelsey Fitzsimmons and respectfully submits a reply brief in the instant matter. The Commonwealth's submission to the full bench dramatically expands its position far beyond the limited scope asserted in the trial court hearing under appeal, and raises new issues that were neither presented nor litigated by them below. Yeah, folks. When the Commonwealth submitted their objection for Kelsey Fitzsimmons to be released, they went all over the board with stuff that is frankly irrelevant. We will get to that. Appellant addresses those new contentions herein in the context of the appeal, whether the Superior Court's revocation of release, issued sua sponte, without notice, without proper findings, and without adherence to GLC 276, 58A or 58B, constituted an error of law warranting relief under SGC Rule 221. Argument 1. The Commonwealth's brief improperly expands the scope of the appeal. Before the Superior Court, in the hearing at issue here, the Commonwealth stated only one simple request: to maintain alcohol monitoring. Appellant, held under the court's order, agreed in principle, but by a different means, and the parties were not in opposition on this issue at that hearing. The probation department likewise agreed there was no violation. Despite this narrow framing, the Commonwealth now submits a 41-page brief addressing everything under the sun: disputed facts, praising and defending the Superior Court's action, also known as ass-kissing, my comment there, and presenting a narrative far beyond the scope of the question that was before the single justice. This expansion is inconsistent with the procedural posture of the appeal vis-à-vis the Commonwealth, and obscures the core issue, the lawfulness of the Superior Court's sua sponte revocation of bail. 2. The Commonwealth relies on allegations the grand jury did not credit. The Commonwealth's principal factual argument relies on the assertion that appellant pointed a loaded firearm at a colleague, pulled the trigger, and attempted to fire again. These allegations were presented to the grand jury. If credited, they would have supported the requested charge of armed assault with no intent to murder. The grand jury rejected that theory and returned only one count of assault with a dangerous weapon, an entry-level Superior Court offense. The notion that that appellant intended to murder a colleague cannot be treated as a credible allegation where the grand jury declined to indict on that basis. Yet, the Commonwealth's brief repeatedly presents these rejected allegations as though they were findings of guilt or fact. Dangerousness determinations must be tethered to reliable evidence, not accusations that failed at the grand jury stage. Yeah, folks, you can indict a ham sandwich in a grand jury. They failed so miserably towards the grand jury that they more or less, by choosing not to indict on the more severe charges, more or less told the prosecution to fuck off. But you can have this instead. Again, my comment. 3. The Commonwealth lacks standing to defend the Superior Court's sua sponte revocation. Because the Commonwealth neither requested revocation nor argued for detention in the hearing at issue, it does not have standing to defend the Superior Court's sua sponte decision. The Commonwealth's stated position below was limited to seeking alcohol monitoring. Monitoring appellant agreed to, although only under the umbrella of the trial court's disputed release framework, provided it could be administered in a manner compatible with her documented injuries. The Superior Court nevertheless revoked bail without a motion from the Commonwealth, without notice to appellant, and without findings under paragraph 58A or 58B. An argument not raised below is waived under Mass Criminal Procedural 30C2. Thus, a party cannot defend on appeal a ruling it did not pursue below. Commonwealth versus Berthold, 2004. 4. The Commonwealth's assertion of trial readiness lacks support in the record. The Commonwealth asserts that it will be prepared for trial in January, a backdoor of saying the wrongful incarceration of appellant, quote, won't be that bad. But at the time its brief was filed, it had not furnished automatic discovery, had not identified the firearm allegedly used, and had not provided materials necessary for independent expert review. Assertions of trial readiness are not relevant to the question at hand and, in any event, are not supported by the current state of the record. 5. Appellant's physical injuries were serious, documented, and directly related to her inability to perform a SCRAM testing. The Commonwealth states that the appellant offered no medical evidence demonstrating her physical condition. This is incorrect. The severity of appellant's injuries, a punctured lung, fractured ribs, and other gunshot-related trauma, was obvious, documented, and reflected in official reports. Probation staff witnessed her difficulty performing SCRAM breath testing due to her injuries. Nonetheless, the Superior Court failed to consider the impact of these injuries on appellant's ability to comply with the condition imposed. The issue before the court until the trial court's surprise SCRAM ruling was her mental state and lack of dangerousness as supported by two esteemed mental health clinicians, not her physical disability. The Superior Court did not address the two expert opinions from Dr. Nisevich of Massachusetts General Hospital and Dr. Zeisel, concluding that appellant did not present a danger to herself or others. 6. Contrary to the Commonwealth statement, appellant proposed a reasonable alternative to SCRAM testing. The Commonwealth asserts that appellant presented no alternative to SCRAM breath testing. The record directly contradicts this claim. Appellant proposed urine testing through a probation-approved vendor, an alternative Assistant Chief Probation Officer, January, identified as feasible. The Commonwealth's repeated statement that no alternatives were offered is inaccurate. And here they quote the timestamps. Yeah. Prosecution. Folks, generally, when the prosecution goes to outright lies, imagine the rest of the case. If they are prepared to lie here, how strong is their case in reality? Think about that for a second. 7. The procedural complexity below resulted from the court's unexpected concerns. The Commonwealth characterizes appellant's litigation posture as piecemeal. Here, repeated filings were necessary to address matters unexpectedly raised by the trial court's position that alcohol testing was indicated, urine testing was unknown to it, and the claim that what proof did it have? Two already filed affidavits, RA 58 and 59, that appellant's rib injury made it difficult to breathe deeply. Appellant's filing addressed issues as the court raised them, not by choice, but by necessity. Yeah, she was shot in the chest. That in itself should tell a person with a normal functioning brain that she might have issues breathing altogether. And a SCRAM breath test will be severely painful. If you have a normal functioning brain, what the judge did, is incomprehensible. But for you who listened to that hearing, you heard that the judge was insanely offended by the attorneys calling it torture. The judge took it as a personal insult, that almost like, oh, Her Majesty's Judge Majesty twatter. She took so much offense that she decided to throw a very deeply injured defendant, former law enforcement, former correctional officer, in jail, putting her into an extremely dangerous situation just because the judge was offended for no apparent reason. Let's continue. 8. The revocation cannot be upheld under either 58A or 58B. The Superior Court's revocation of release did not comply with either statutory scheme. A. If treated under 58B, required procedural protections were absent. Revocation under 58B requires notice, a hearing, findings of willful violations or new dangerousness. None of these occurred. B. If treated as a reconsideration under 58A, due process was still required. The appellee stated that the decision was, quote, not a revocation, but rather reconsideration. Regardless of label, 58A requires notice and an opportunity to be heard before modifying a release order. Appellant received neither. Appellant's liberty may not be revoked under a statute that does not permit revocation based on the facts at hand, particularly without observing the procedural safeguards required by due process. 9. Footnote 8 and footnote 9 of the Commonwealth's brief contain significant misstatements. This is legal speak for they lied. Footnote 8 presents a characterization inconsistent with the record and unsupported by any judicial findings. Footnote 9 misstates the role of the full bench under the SGC Rule 2.21, suggesting that the full court is limited to reviewing the single justice's determination. In fact, when the single justice makes an error of law, the full bench performs de novo review and resolves the underlying bail question to prevent further unnecessary delay and a remand to a lower court judge who would have already made an adverse and then reversed ruling consistent with Stack v. Boyle from 1951. 10. The trial courts and the Commonwealth's discussion of mental health history omits the uncontroverted expert opinions. The Commonwealth references appellant's mental health background without acknowledging the two expert evaluations concluding that appellant was not a danger. These opinions are unchallenged in the record and must be considered in any dangerousness analysis. 11. Alcohol use played no role in the underlying incident. The allegations concerning alcohol derive from an affidavit submitted in a separate context by an individual with motives unrelated to this criminal matter. No police reports or charges are extant from this alleged behavior at a bachelorette party in Maine. No witness has been cross-examined or questioned under oath as to any of this alleged behavior. There is no rational basis to credit this piece of paper filed to gain advantage in a custodial family court matter. Yeah, folks, this is her ex. You know, the ex who abandoned his girlfriend and child when the girlfriend was experiencing postpartum depression. So this sorry excuse of a human being who abandoned the mother of his child, who leaped in directly in, well, this is my interpretation of the facts, who leaped into the bed of another woman almost basically immediately. You might even consider that it might have been ongoing while Kaylee was pregnant. Is there evidence of that? No, it's my interpretation. Because when a man has that low morals, why wouldn't he? But back to this. In contrast, law enforcement officers present on the day of the incident did not report that alcohol was a factor in any way whatsoever and found a normal mother happily at home with their 4-month-old baby. The trial court's revocation cannot be justified based on untested allegations unrelated to the incident, particularly in the shadow of the mountain of evidence to the contrary. 12. The Commonwealth did not address the ADA arguments in its brief before the single justice and therefore waived it. Appellant argued before the single justice that SCRAM breath testing was medically impossible due to her injury and that the Americans with Disabilities Act require a reasonable accommodation. The Commonwealth did not respond to this argument. Its first discussion of the ADA appears in the appellee's full bench brief, and was ignored by the Commonwealth in the single justice session. Under Rule 16A, 9A, argument raised for the first time on full bench review need not be considered. Conclusion. For the foregoing reasons, Ms. Fitzsimmons respectfully requests that the Supreme Judicial Court 1. Addresses the bail determination de novo, consistent with the applicable case law, and grant Ms. Fitzsimmons liberty with personal recognizance and a stay-away ordered from the alleged victim under Section 57, which is no finding of dangerousness required, or Section 87, bail terms imposed with agreement of the defendants, of the bail statute, and vacate the balance of the trial court order, including the provision handicapping the probate and family court from handling the custody and visitation decisions in the case, and /or grant other such non-incarcerative relief in the alternative if the court deems 58A conditions necessary, and send the case back to the Essex Superior Court before a different judge for the reasons set forth above. Wherefore, Ms. Fitzsimmons respectfully requests that the Supreme Judicial Court justices enter the appropriate orders as above. Respectfully submitted for the defendant, Timothy Bradel, Martha Coakley. And with the affidavit of Timothy Bradel and all the certificate of compliance and service and all the things. Yeah, folks, this is insane. First, the trial court, who is, in lack of better words, unhinged, and in my opinion, if this is something that happens in her court regularly, she shouldn't be a lawyer at all, because you do not treat a court like it's your personal sandbox. It isn't. Just because you wear the robe does not mean that you fit in the robe. Now we can only hope that Kelsey, that the full bench takes a look at this and does as Ms. Fitzsimmons' attorney suggested. Please send Ms. Fitzsimmons home with a reasonable bond provisions. Thank you, folks, for listening in. You all have a good one, and I will see you all in the next stream or video. Bye-bye.